Ms. Lundy, everybody may be seated. And I apologize for interrupting you in the middle of closing.
I'm
The
terribly.
behavior from him, from Mr. Bloom, I am not going to have in terms of his gestures, his noise and everything, particularly behind Ms. Lundy's back. Not going to have it. Mr. Burnton, I'm going to give you a chance to talk to your client about it and tell him that he is to sit there quietly or not at all before I continue. Take him back. Court is standing in recess.
All right.
The next district court of County, Washington, State of Michigan is now back to session.
You may be seated, but I'm going to admonish you and warn you at this time that the court is not going to allow that type of conduct to occur. With that admonition, are the parties ready for the jury?
Your Honor, I also understand there's been information given to the jury that.
Correct. Yes, for the purposes of the record, I did inform counsel. So at no, that the jury did not take that in any way to be applicable either to Mr. Bloom or to the people, because I had stopped Ms. Lundy in the middle of her closing argument. And I had indicated that they are not to take any delay or interruption by the court. They are not to attribute it to either party. They are to attribute it to the court of its own doing, so that the jury understands that and does not hold that against the people or against the defendant.
Thank you, Your Honor. I am ready to proceed.
Is the defense ready?
I am ready, Your Honor.
All right, let's bring the jury. What is going on? All right. Go ahead. Thank you. Court does call the case of the People versus Bloom.
Good morning, Your Honor. Sam Bernstein here on behalf, not exactly with Mr. Bloom.
All right. We've had numerous discussions regarding the defendant's participation, just so that the record is clear. The defendant left the courtroom during the course, or at the very beginning, at least I think at the beginning portion of the people's closing argument. Upon his leaving and reviewing some case law at that point, we adjourned it to the continuation of the trial to today. Looking at additional case law without a great deal on point, and I don't have that. Yes. We had started out with, I believe it's the Swan case, People versus Swan. That's at 394-451, which we knew about last week, to try to deal with Mr. Bloom's absence from the proceeding. This morning, I had told counsel that the court additionally found the case of People versus Palmerton. That's at 200 Mishap 302, the 1993 case. And the long and short of it is that the defendant, to have a valid waiver of his right to be present at trial, that has to be established on the record. My understanding is that the defendant does not wish to come out. He is up in the court's lockup, but does not wish to come out and be present for these proceedings. Is that correct, Mr. Bernstein?
That is correct, Your Honor. I have spoken with him, expressly relayed that he has a right to be at the trial proceedings. Mr. Bloom states that he does understand that and he wishes to waive that right and have the closing argument in his absence.
All right, very good. And you're satisfied that he understands and is knowingly waiving his right to be present during the trial?
I am, Your Honor. Today was not the first time that I spoke about it, and I do think that he understands that he has the right to be here and wishes to waive that.
All right. Does either side need, I I don't think there's any disagreement that Mr. Bloom is up here because Mr. Bernstein has talked to him. We could put on at least testimony of the officer or one of the transport officers to indicate that his understanding is that Mr. Bloom does not want to be present. Does either party think that is necessary given the representations of Mr. Bernstein?
Your Honor, I have absolutely no reason to doubt Mr. Bernstein. The only concern that people brought forward to the court was if there is a conviction and there is an appeal of that conviction, if Mr. Bloom may make representation that is not what he told Mr. Bernstein, I would request that the court make a very short inquiry of one of the transport officers that it's their understanding as well, if the court would be so inclined.
That may make sense. So if we could have, was it Officer White? Was it?
I do think Corrections Officer White is up.
Yes, if you could come out. Deputy White, if you could come to the podium, please. Mr. Allen, if you could swear him in, please.
All right, do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State and spell your first and last name for the record, please.
Matthew White, MATTHEWWHITE.
All right. And you're employed with the Washington County Sheriff's Office
Yes,
and in the transport division.
that's correct.
All right. And you were in part responsible to transport Mr. Bloom to these proceedings today.
Yes,
And he was brought up from the jail to the lockup off of the courtroom. Is that correct?
yes.
All right. During the course of that, and in terms of getting him ready for trial, did Mr. Bloom make any representation to you or in any way indicate to you that he did not wish to participate in these proceedings?
Yes, he did. He just said that he felt like his trial was over and he didn't need to be present.
All right. And is it your understanding that he does not wish, based upon those conversations and his actions, is it your understanding that he does not wish to come out and participate in these proceedings?
Yes.
All right. Any questions from the people?
Your Honor, people are satisfied.
Any questions from the defense?
No, Your Honor.
All right. Thank you, Corporal. All right. I think we dealt with that matter. There is then the issue of an instruction to the jury. During a break while we had an opportunity to speak, I had an opportunity to speak to counsel. I asked them to draft something that they would believe would be sufficient to instruction to give to the jury. They have drafted, and we have a copy of the instruction that I believe the parties wish read to the jury. Mr. Bernstein brought up the point that not to necessarily read that, or it could be read with my final instructions, but that the real issue was that there had to be some explanation or something to the jury once they came into the courtroom. And so I had indicated, if there's no objection, that I would read that. Excuse me one moment. That I would read that once the jury enters the room. The instruction that counsel has presented is that during the course of this trial, the defendant has chose to no longer be present for the proceedings. His absence should in no way impact your deliberations and verdict. Is that a correct understanding of?
Yes, Your Honor.
It is, Your Honor.
All right, very
Does the
good.
court consider giving it to the jury when they come in, and then also in the final instructions?
I would consider that. I certainly was going to give it on Mr. Bernstein's request once they came in to explain the defendant not being present. If you wish me to give that during the closing instructions, I could do that also.
If the court wouldn't mind that, the people would appreciate that, just so it's very clear that this is your new instruction, and when the court instructs the jury to take the jury instructions as a whole, I think it would be helpful just to have that included as well, that is a piece of this trial.
All right. Very good.
I don't mind. It's belt and suspenders, so.
Haven't
I
heard
just
that.
want to say that.
Haven't heard that in a while, but yes, okay. Just want to make sure I have 11. I think then what I would do is, since Mr. Bloom did not testify, I would insert the reading of that instruction around that same point as the reading of 3.3 to defendant not testifying. I think, yeah.
Sequentially, that seems to make sense. Thank you, Your Honor.
May you see it? Your Honor, the jury is present.
Thank you. Good morning, ladies and gentlemen of the jury. Initially, what I would do is I would give you an interim instruction and just tell you that during the course of this trial, the defendant has chosen to no longer be present for these proceedings. I would admonish you and ask you to remember that his absence should in no way impact your deliberations or your verdict. All right. Ms. Lundy, we're at the point of closing arguments. And I believe when we stopped, you were in the middle. However, you may begin again with your closing argument.
Thank you, Your Honor. Your Honor, with the court's indulgence, at this time, I'm going to end my closing argument. I trust that the jury remembers it and remembers what I had to say. And I don't see the point in sort of rehashing all of it. They've been paying diligent attention. If that's okay, if that pleases the court and defense counsel.
That is fine with the court.
Thank you. I do reserve any further argument for rebuttal closing.
Thank you.
Thank you.
Mr. Bernstein, closing argument.
Thank you, everyone, for coming back. That day, Rocky saw Jeff in the jail and found Jeff to be yelling, saying he didn't trust him. And we've been through this trial now together, and we've seen how that has all played out. And my question for you guys is, where's the beef? Really, where is the beef? There was a question posed to Rocky. Did he have any reason not to trust you? Rocky said, not at all. There were no problems between Rocky and Jeff. There was no history between Rocky and Jeff. I don't mean to minimize any impact from this on Rocky. The prosecutor in her closing did a good job of talking about the emotional connections that we have with nurses. I get it. My wife's a nurse. My grandma was a nurse. That's not exactly the situation here, though. This wasn't the cozy urgent care. Rocky said when he met Jeff, Jeff is just screaming uncontrollably. He's in fear for his life. He doesn't trust him. There needs to be an officer to calm him down. It's just not a normal situation. And I can understand how Rocky feels the way that he does. After he leaves there at first, there's no problems. Nothing hurts. He walks away. Then he starts talking to people. He starts retelling the story. There's his email. There's his medical records. The story changes. It does. The situation that we do have here is that there are two officers standing right there. Both officers said that they did not see Rocky hit that door. They did not see Rocky hit that door. They did not see Jeff grab Rocky. We watched a video twice. That video showed nothing at all. Of course, there was one major way that we could have resolved this. There was a camera pointed right at Jeff's cell, and no one talked about doing anything to see if that camera captured it. Instead, we were shown a video that showed nothing. I come back to my original question, guys. The original question I posed, where is the beef? And I don't mean motive. Okay, this isn't an Agatha Christie whodunit novel, right? But like, why? The question isn't whether Jeff pulled his arm back. The question is, why did he do it? If there is no intent to commit a battery, then there is no battery. Without intent to commit a battery, there is no crime. Without a beef here, there is no battery. We asked you here for your help, and I get how we got to this point. Jeff is not going to get the benefit of the doubt. He was in jail. That's fine. I get it. A lot of what's been talked about in this trial has always come with an explanation. It's been glossed over, minimized, explained away as if these things don't matter. Does it not matter that Officer Navin testified that he was standing right there and didn't see that happen? That he didn't see Rocky hit the door? Does it not matter that Officer Tweedell was standing right there as well and did not see Rocky hit the door? We saw a video twice that didn't even show anything. We didn't hear about any efforts of anyone trying to get the other video. I mean, does it not matter that Jeff is having an emergency? Does it not matter that there's a perfectly reasonable explanation for this? That's not a crime. The guy's freaking out and doesn't want Rocky to touch him. He's talking about he's in fear for his life. Jeff doesn't want to hurt the guy. He has no beef with the guy. He has no beef with Rocky. I say that these things do matter. Jeff does deserve the benefit of the doubt. And legally speaking, he gets that benefit of the doubt unless you are really shown something otherwise. But we have not seen that here. Absolutely not. You are the only people that can help Jeff. And we have asked you here to listen, and we are asking you now for that help.
Thank you, Mr. Bernstein. Rebuttal.
Defense counsel says you are the only people here who can help Jeff. But that's not true. Because there were plenty of people who tried to help Jeff on the day that this happened. There were guards to get him the medical attention he wanted. A second guard brought in to make sure nothing happened. And Rocky brought in to assess his vitals and see if he needed emergency medical treatment. All three of those people tried to help Jeff on that day. All three of those people tried to get the defendant the help he needed to keep him safe, which is what I talked about last week. Safety is the priority of the three men that you heard from. That's their job. Defense counsel's asking, does it not matter that this guy is freaking out? Look at the law. Look at the jury instructions. Listen to the ones that you're about to hear and consider. Does the motive matter? No. And that his intent can come from all of the surrounding circumstances. And what does he do with that blood pressure cuff after he pulls it into that cell? Waves it around like a lasso. It's a game. It's a game for the defendant. Mr. Burnside says this video shows nothing at all. Except that that's not the case, because the video shows you exactly what Officer Navin testified to, exactly what Officer Tweedale testified to, and it shows you Tweedale standing there, frankly, making a better door than a window, blocking the view of the camera. Those men easily could have come up here and said, yes, I saw the whole thing. I saw Rocky get slammed, but they don't, because that's not what happened. They're focused on Jeff. They're focused on the defendant. They're focused on this person who's demanding medical attention, and they're so concerned they do it through the food slot.
Rocky told you how he had his arm, and he showed you, demonstrating he had his arm all the way out, bent all the way down. This isn't like somebody got grabbed by the hand and pulled in. This is somebody who's already extremely close to that door. The defendant's the only person that day who made a choice to compromise the safety of another human being. People are asking you to hold him accountable and convict him.
Thank you. Members of the jury, the evidence and arguments in this case are now finished, and I will now instruct you on the law. That is, I will explain to you the law that applies to this case. During the course of this trial, the defendant chose to no longer be present for the proceedings. His absence should in no way impact your deliberations and verdict. Every defendant has an absolute right not to testify. When you decide the case, you must not consider the fact that he did not testify. It must affect your verdict. It must not affect your verdict in any way. Ladies and gentlemen, you have heard testimony from witnesses that are correctional officers. That testimony is to be judged by the same standard you use to evaluate the testimony of any other witness. The defendant in this case is charged with the crime of assault and/or assault and battery. The prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant committed a battery upon Rocky Isley. A battery is a forceful, violent, or offensive touching of a person or something closely connected with the person of another. The touching must have been intended by the defendant, that is not accidental, and it must have been against Rocky Isley's will. It does not matter whether or not the touching caused an injury. Second, that the defendant intended either to commit a battery upon Rocky Isley or to make Rocky Isley reasonably fear an immediate battery. As used in these instructions, the words force or violence means the use of physical force against another person so as to harm or embarrass them. For a battery to occur, the touching must have been intended by the defendant. That is not accidental, and it must have been against the will of Rocky Isley. Does not matter, as I've indicated, whether or not the touching caused an injury. You may be seated. Any objection to the instructions as given by the court?
No, Your Honor.
I have none, Your Honor.
All right, thank you. And on this matter, we will stand in recess on the Bloom matter until such time as we have a verdict and or questions or inquiry from the jury. Thank you. Okay, court does call the case of the People versus Jeffrey Bloom.
On for the people.
Good morning again, Your Honor. Sam Bernstein for Mr. Bloom.
I have been informed that we do have a verdict, and that gets us to, I guess, another proceeding. And by way of caution, I asked Mr. Bernstein to talk with his client as to whether or not he wishes to be present for the verdict. Mr. Bernstein.
He does not wish to be present, Your Honor. He understands that he could.
All right, very good. I will assume that the waiver that was in place before is continuing. Would I be incorrect in that assumption?
I would agree with that assumption.
All right, very good. Are the parties ready then to receive the verdict?
They are, and for the record, the people would be fine with Mr. Bernstein's assertion to the court about that, about his final option to be present for the verdict. While, of course, the reading of the verdict is a critical stage of the trial, it has perhaps a different procedural effect that people say in trusting Mr. Bernstein's assertion.
All right.
I'm likewise ready for the verdict, Your Honor.
All right.
All rise for the jury. Seated. Your Honor, the jury is present.
Ladies and gentlemen, the court is of the understanding that you have reached a verdict. Do we have the verdict? And that back to the foreperson. Ladies and gentlemen, the jury, who speaks for you? All right. And sir, you have reached a verdict. What is that verdict?
We have reached a verdict of not guilty.
All right. Would either side like the jury poll?
No, Your Honor.
No, Your Honor.
All right, very good. Ladies and gentlemen, I want to thank you very much for your service. We will send you back. I'll be back to formally excuse you momentarily. I know this has been a weird kind of journey having to come back, but I do appreciate your patience in helping us get through this. All right, thank you. Mr. Allen, you may take the jury.
Jury.
On this matter, is there anything else?
No, Your Honor.
All right,
No, Your Honor.
thank you. 14A stands in recess.